Appeal in the matter of Kanhirakandan and Secretary of State for the Home Department.
Yes, Mr. Mayor.
My lords, my lord, my ladies, I'm here for the appellant this morning with Mr. Kareem. Ms. Portal appears for the Secretary of State. Well, this, as the court knows, is an appeal from the upper tribunal's decision allowing the Secretary of State's cross-appeal against the decision of the first-tier tribunal. The upper tribunal allowed the cross-appeal on the basis of fresh evidence, the evidence that was not adduced at the trial. I shall seek to persuade my lord and my ladies that the upper tribunal applied the wrong test and in any event made a decision that is not justified on the test it applied. So subject to any observations, what I propose to do this morning is to address you first on the law, focusing on the legislative scheme and seeking to assist you on three particular points made by my learned friend in her skeleton argument. I will then make brief submissions as to the facts of this case and the decisions made below.
Okay.
So the law first. In my respectful submission, the starting point ought to be the 2007 Act. You have that behind tab 1 of the authorities bundle.
Yeah.
And my lord and my ladies will see that the first-tier tribunal and the upper tribunal are creators of this statute. This is section 3 of the 2007 Act, page 4 of the bundle.
Yeah.
Section 11 of this Act deals with an appeal from the first-tier tribunal to the upper tribunal. You have that provision at page 21 of the bundle.
Yeah.
You'll see that under subsection 1, there is a right of appeal to the upper tribunal on any point of law arising from the decision made by the first-tier tribunal. Any point of law are the words that I respectfully emphasize. Subsection 3 tells us that the right may only be exercised with permission, and permission may be granted by the first-tier tribunal or the upper tribunal. This is quite similar, in my respectful submission, to the right of appeal from the upper tribunal to this court, and that is governed by section 11 of this Act, page 27 of the bundle. You'll see that the statutory language is quite similar. The principal difference, of course, is that on an appeal from the upper tribunal, the appellant has to meet the second-tier appeals test. That test does not apply on an appeal from the first-tier tribunal to the upper tribunal. But the basic point that one gets is that an appeal is available only on a point of law. Behind tab 8 of the bundle, you have the first-tier tribunal procedure rules. These are the rules made under the statute. And they, in my respectful submission, will assist the court as to the procedure at the first instance tribunal. May I ask respectfully for the court to go to page 211 of the bundle and see part 3 that concerns proceedings before the tribunal. You'll see that under Rule 9.1, an appeal is initiated against a decision by issuing a notice of appeal.
Rule 19.1.
Rule 19.
This is first-tier tribunal.
Yes, yes.
Okay.
So an appellant files an appeal, the Secretary of State makes a decision, the appellant files an appeal to the first-tier tribunal. If you then go to the next page, page 212, it's Rule 19.6. The tribunal then serves a copy of the notice of appeal provided by the appellant on the respondent.
Yeah.
Rule 24 tells us what a respondent must do on receipt of a notice of appeal. You'll see that it says that when a respondent is provided with a copy of notice of appeal, the respondent must is the word that I respectfully emphasize. So there is an obligation on the respondent to provide the tribunal with the notice of decision. This is Rule 24(1)(a). Any other documents the respondent provided to the appellant giving reasons for that decision. If you then look at D, any other unpublished documents, any other unpublished document which is referred to in a document mentioned in subparagraph A, namely the decision and the reasons, or relied upon by the respondent. So the obligation on the respondent is to provide not only the decision under appeal, but any document that is mentioned in that decision or any other document on which the respondent seeks to rely on. And if you then look at Rule 24(3), you'll see that there is a time limit, and the time limit is 28 days from the date on which the tribunal sends a copy of the notice of appeal to the respondent. Now the scheme in my respective submission is clear. The appellant files a notice of appeal. The respondent then serves all the documents on which he seeks to rely on. And if you then go to the next page, page 214, the tribunal then issues a notice of hearing, and there is then a hearing. Now, if the respondent fails to comply with Rule 24, the tribunal proceeds on the basis that the respondent is not seeking to rely on the document that he or she has not adduced in accordance with Rule 24. This is what the Deputy Presidential Panel has said in MH. MH, respondents bundle documents not provided. You have that authority behind tab 5 of the bundle. So you'll see from the summary, classic case where there was an allegation that false documents were submitted, the failure to comply with the duty under Rule 24, which was then Rule 13. If you look at the conclusions as set out in the head note, I'll take you to the body of the judgment. This is really the first few lines at page 95. The intention that Rule 13 is mandatory. The intention is to enable the appellant to know the case he had to meet and the tribunal to have the material upon which the case could be judged. The tribunal was entitled to conclude that document not furnished under Rule 13 was not a document on which the respondent relied. You'll see that analysis in the judgment at paragraphs 12 and 13, page 98 of the bundle. You'll see that at paragraph 12, the panel quoted Rule 13, which is now Rule 24. You'll see that the language is the same. And you'll see the analysis at paragraph 13 as to what is the intention of that rule. It's the same as was stated in the head note. If there are documents relating to forgery which ought to be in the public interest not to be disclosed, then there is a procedure that can be adopted. And you'll see that the tribunal placed particular emphasis on the use of word or in the rules. If a document is not provided by the respondent to the tribunal is entitled to conclude that the respondent, if a document mentioned in the decision is not provided by the respondent, the tribunal is entitled to conclude that that reference no longer form parts of the Secretary of State's case.
Okay.
So this is Rule 24 of the first year Tribunal Procedure Rules and the authority on it. May I then take you to the upper Tribunal Procedure Rules? Tab 7 of the authorities bundle. And may I respectfully take you to page 148 of the bundle and ask you respectfully to look at Rule 15. Now this concerns evidence and submissions. So evidence assuming that it is admissible and capable of establishing an error of law. This rule governs such evidence. If you look at page 149, you'll see Rule 15(2)(a). That is the rule that concerns immigration and asylum cases. So if a party wishes the tribunal to consider evidence that was not before the first year tribunal, the party is obliged to send or deliver a notice to the upper tribunal or any other party. And you will see an obligation to indicate nature of the evidence and explaining why it was not submitted to the first year tribunal. And then 2(a)(b), when considering whether to admit evidence, assuming that it is admissible and capable of establishing an error of law, the tribunal will have regard to any unreasonable delay in producing that evidence. So that is the rule about the evidence. If you then go to Rule 21, this is page 155 of the bundle. And this concerns applications for permission to appeal to the upper tribunal. So a party who is not happy with the decision may appeal to the upper tribunal, may seek permission to appeal to the upper tribunal, but they can only do so, this is Rule 21(2), if they have made an application below, namely to the first year tribunal, and that application has been refused or not admitted. Rule 22 concerns the decision on an application for permission to appeal. You'll see that if the upper tribunal grants permission to appeal, what then happens is that the upper tribunal sends a notice of permission and other documents on the other side. The application for permission to appeal essentially stands as the appellant's notice. So what a respondent must do on receipt of a notice of appeal following the grant of permission is set out at Rule 24. You have that rule at page 161 of the bundle. Now you'll see from 24(1)(a) that the respondent has a choice in certain circumstances as to whether or not to file a response, but a duty to file that response if sub-rule 1B applies. And that is an instance where the respondent wishes the upper tribunal to uphold the decision for reasons other than those given by the upper tribunal, or relies on any ground on which the respondent was not successful in the proceedings below. If the respondent seeks to challenge the decision made below, the respondent must apply for permission to appeal. This is 24(1)(c). There is a time limit to file this response, and that time limit is in Rule 24(2)(a). So a response under Rule 24 must be in writing and must be filed no later than 1 month of the grant of permission, or the date on which the grant of permission was sent. So these are the relevant provisions in the upper tribunal procedure rules. The rules are there for a reason. May I then make some brief submissions on the key authority on the subject, the authority that both sides have referred in their skeletons, and the authority that the upper tribunal considered. That is the judgment of this court in E&R. You have that judgment at page 46, that judgment at tab 3 of the bundle. Now that, if you look at the summary at page 47, between letters E and F, you'll see that this related to the predecessor of the first-year tribunal and the upper tribunal, namely the Immigration and Asylum Tribunal. There was an appeal from the tribunal to this court on a point of law. There wasn't any two-tier system below, so the tribunal had a power to review its decision and to review that decision, and that power was quite wide. And the issue before the court, this is paragraph 1 of the judgment. You have that paragraph at page 55 of the bundle. The issue was about the powers of the tribunal, the Immigration and Appeal Tribunal, and this court to rely on fresh evidence to interfere with the decisions made earlier. And may I then ask the court respectfully to go to page 62 of the bundle. You'll see a heading, the tribunal's powers to direct a rehearing. So the position then was that a judge makes a decision, but the tribunal had the power to review that decision in certain circumstances. And you'll see that E and R argued, this is paragraph 30, that the rules that were then in place were general and unqualified in nature, and there was a power to direct a rehearing in certain circumstances. So the rehearing, the power to order a rehearing was not limited to an instance where the tribunal finds that there is an error of law in the first judge's decision. If there is new evidence, the tribunal feels that it is appropriate to order a rehearing on that evidence, the tribunal will order a rehearing. The reasons for that are set out at paragraphs 35 of the bundle. Paragraphs 34 and 35 of the bundle. If you look at the quotation in 34, I mean, in a typical asylum claim, A judge hears the appeal. Following promulgation of the appeal decision, new evidence comes to light that demonstrates that an asylum applicant faces a risk of persecution in their country. The new evidence may well be a change in the country's situation. The tribunal had a broad power to simply order a rehearing on the basis that it's best to simply rehear the case rather than ignoring the new evidence. So that was the broad position at the time. The position now is quite different. So there is no power to review the decision simply on the basis that there is new evidence. A person who is not happy, a party who is not happy with the decision may seek to appeal to the upper tribunal, but only on a point of law. There is no appeal on facts. If you then go to page 72 of the bundle, you'll see a heading, underlying principle. Well, this relates to establishing an error of law on the basis of fresh evidence. The court had to grapple with those principles because there was an additional issue as to the powers of the court, this court, to receive new evidence. Paragraph 63 of the bundle, paragraph 63 of the judgment, page 73 of the bundle, you'll see that that 5 matters were identified where fresh evidence could be admitted, so to establish an error of law in the decision made below. And you'll see that decision turned on 5 particular matters. There was a mistake of fact. There's a mistake of fact, mistake as to or ignorance as to the relevant fact. The fact was established in the sense that if attention had been drawn to the point, the correct position could have been shown by objective and uncontentious evidence. So in this immigration asylum context, that could be an issue as to the paternity of a child. Then there was DNA evidence that shows beyond any doubt that there is a relationship, or in case there's a dispute about nationality of a person, and that person then provides a passport demonstrating that he's a British citizen. Third, the claimant, i.e. the person who is seeking to rely on fresh evidence, could not fairly be held responsible for the error. So the party who seeks to rely on fresh evidence may not rely on their own mistake or on their own error. And then fourthly, that, well, in that case, it was said that the claimant, it was the claimant to prove her case, and there was a duty and shared interest in cooperating with the tribunal. The position here, common ground, is that the burden of proof was on the respondent. The appellant had no burden. And finally, the mistaken impression played a material part in the reasoning. The conclusions are set out at page 81 of the bundle. You'll see a heading just above paragraph 90, conclusions, and the 2 paragraphs on which my lords and my lady will focus are, of course, paragraphs 91 and 92. It is, in my submission, quite clear that at paragraph 91, the court was considering the powers of this court to admit fresh evidence in an appeal that was available on a point of law from the tribunal. At paragraph 92, the court was considering the powers of the tribunal to review the first decision, and a review, as I sought to demonstrate, was available irrespective of whether there is or isn't an error of law. So looking at 91, the appeal to this court on a question of law is confined to reviewing a particular decision of the tribunal. The same applies to the upper tribunal now, and does not encompass a wide bar to review the subsequent conduct of the Secretary of State. But an appeal may be made on the basis of unfairness resulting from misunderstanding or ignorance of an established or relevant facts. And the admission of new evidence is subject to Latin Marshall. This is the approach that, in my respective submission, applies with equal cogency to an appeal from the first-tier tribunal to the upper tribunal.
So you say this is a paragraph 91 case?
Absolutely. Yeah. If you look at paragraph 92, you'll see that the difference is obvious. At paragraph 92, you'll see that that concerned the role of single-tier tribunal as it then was, the IAT. The tribunal remained seized of a decision and therefore able to take new evidence into account up until the decision is promulgated. And if there is then, following the decision, there is a wide discretion to direct a rehearing. And what is more important is that that bar is not dependent on its finding an arguable error in the original decision. But Latin Marshall is a good guide. Not the test, but a guide. Surely a 91 case.
That's common ground though, isn't it? Ms. Pottle agrees with you.
Yes, but
I mean, the issue here is whether the exceptional circumstances.
yes.
That's really the issue. Assuming that the Latin Marshall principles can't be met because the Secretary of State had the material at an earlier stage and therefore it can't be said
Yes.
it was new evidence in that sense.
Yes.
The real question is whether there were exceptional circumstances in the present case,
Yes.
where it is said against you that otherwise the tribunal would have been positively misled,
Yes.
or at least arguably positively misled, because
Yes.
the point hasn't been decided yet.
Yes. Of course, I recognize that. Can I just make one short point in response to this particular observation, which is this, that, well, on Miller and Friends case, as is now common ground, that it's the paragraph 91 applies, and it is for the upper tribunal to apply that paragraph and decide whether there are exceptional circumstances. Now, that is the decision, in my respective submission, for the upper tribunal. Now, if this court is persuaded that the upper tribunal applied the wrong test,
Well, they cite 92.
yes, now, if
Maybe that's a mistake.
yes,
So we need to look
Yeah.
at what they did.
but precisely. But if the submission that I make with respect is that if the upper tribunal has not conducted, and of course it's a question for the court as to what the upper tribunal has done, but if the upper tribunal has not conducted the exercise under paragraph 91, then this court should be slow to decide for itself as to whether there are or there aren't any exceptional circumstances. And of course, the court can dismiss the appeal if the court concludes that, well, on any view, there are plainly exceptional circumstances and there is no room for a different view. But if the court takes the view that there is a room for a different view, then in my submission, it would be appropriate to leave that decision in the hands of the upper tribunal rather than substituting the court's own view. Of course, you'll hear submissions.
If we're satisfied, there's an earlier stage, isn't there, that before we get to any sense of disposal,
Yes.
we have to be satisfied that the upper tribunal, Judge Mandalia, made an error of law.
Yes.
And from speaking for myself, it's not enough just to say, oh, look, he cited the wrong bit of
No.
VNR. We have to look
No.
substantively at the approach that he took.
Completely agree, and I'll make submissions on that. If I'm not able to persuade the court that the upper tribunal applied the wrong test, that's the end of ground one. But you will have my submissions on ground two. So this is what ENR says. Now, can I then very briefly deal with the 3 points, 3 particular points that my learned friend has made in her skeleton argument. Now, one point that my learned friend makes, in effect, is that there ought to be a special rule for the Secretary of State. She says that, well, where an applicant is unsuccessful before the tribunal and there is fresh evidence, that applicant can make a fresh application to the Secretary of State. Whereas the Secretary of State can't do any such thing. If the upper tribunal if the tribunal makes the wrong decision, then the Secretary of State is bound by it. There's nothing that she can do. And this is, in my respectful submission, a theme that runs through my learned friend's case, and the upper tribunal said something similar to that effect in their decision. There are two prime difficulties with that approach. The first is that it is simply wrong, and it is factually wrong, and secondly, it's wrong in principle. It's wrong in principle because it is an elementary principle that both sides in a litigation ought to be treated in the same way. But it is wrong, it's factually wrong, because the Secretary of State is not tied, contrary to what my learned friend said, and contrary to what the upper tribunal said, with a bad decision. There are two things that she can do. She can refuse to apply that decision. She can refuse to implement that decision. Now, what has happened here has happened in a catalogue of reported cases. I'll take you to an authority. In a classic, it happens, I mean, in a classic case, I'll take you to that in a second. An applicant gives evidence before the tribunal that he has lived in this country continuously for 14 years or 20 years, and the tribunal allows the appeal on that basis. The Secretary of State then checks the records, and it appeared that that person had actually been traveling. The Secretary of State can it's not, of course, for me to advise the Secretary of State as to what to do, but what she can do in those circumstances is to say that I'm not going to implement this decision, because there is now evidence which shows that the decision is wrong, and the tribunal was misled. That's one thing that she can do. The other thing that she can do is that she can go back to the tribunal itself, the first-year tribunal, and to say to that tribunal that, well, you have given a judgment, and that judgment was obtained by fraud, or the appellant was dishonest. Set aside that judgment on that basis. And the tribunal would do so. The authority on the subject that reconciles all earlier authorities on the subject is Abbasi, tab 6 of the bundle. So, classic case, as submitted, what is alleged to have happened in this case is not unique. I mean, it happens in this jurisdiction, unfortunately. So Abbasi is a case where the upper tribunal allows the appeal, promulgates a decision, and it then emerged that the evidence that the appellant had provided was false. The upper tribunal, the presidential panel, reconvenes the hearing, and there was a detailed discussion as to the options available. Now, may I respectfully take my lords and my lady to page 112 of the bundle.
Yeah.
And you'll see a heading above paragraph 9, the respondent's ability to take action. There's a discussion of a number of authorities. The presidential panel says that there is a body of case law that considers the circumstances in which the respondent may refuse to give effect to a decision, now the first-year tribunal, on the basis of fresh evidence. Ulla, that is referred, was a case where, as I said, an appeal was allowed on the basis that the appellant has been here for 14 years. That evidence turned out to be false, and there was a discussion. Now, if that happens, I mean, Ulla was a case where there was a discussion as to whether Ladd and Marshall would apply in those circumstances. But there is a broad, there is that option, a bar to decline to implement a decision. Now, if you then go to page 118 of the bundle, you'll see a heading concerning the judgment. I'm sure the court is familiar with it. Tacker, that of course, as the court knows, was a case where a judgment was obtained by fraud. Fresh evidence showed that it was obtained by fraud, and the issue before the Supreme Court, and there was the losing party applied for the judgment to be set aside, not appealed, but set aside on the basis that there was fraud. The evidence established that. There was a discussion as to whether Ladd and Marshall applies, and the Supreme Court held that, well, Ladd and Marshall would not apply, so you can simply go back to the court that was defrauded and ask it to set aside the judgment. And this is what the upper tribunal essentially held. This is paragraph 54, page 124 of the bundle, that where there was a dishonesty or the evidence was false, then there is something in the rules. Go back to the same court, go back to the same tribunal, say that, well, there is an administrative irregularity in the decision-making process, and you set aside that decision. It's perfectly open to the Secretary of State, and to go back to the first-tier tribunal, the judge who was misled on the Secretary of State's case, and to say that, well, you were misled.
These are fraud cases.
In a case where there's dishonest evidence, and the Secretary of State makes in effect the same point here, that this is a case involving dishonesty. The appellant gave false evidence to the tribunal. So that is the answer to that point that Miller and Friend makes. Now, the second principal point that Miller and Friend makes in her skeleton, and again, that is a point that runs through the analysis in Miller and Friend's skeleton and the upper tribunal's decision, there's got to be some special rule for fraud or for deception. Miller and Friend says that, well, dishonesty is very serious. It's a very serious matter. It is indeed very serious, but so is a case where there is a risk to life, an asylum claim. If you allow a special rule for deception cases, what's wrong in an asylum applicant to say that, well, my case is even more serious than an allegation of deception. If you return me pursuant to this decision, which the new evidence shows is wrong, I will face persecution. So the seriousness of the issue, in my submission, is completely irrelevant. If it is relevant, then it will be relevant for both sides. The third and final principal point that Miller and Friend makes is that, well, it's not required to establish that there is unfairness to a party. As long as there is objective unfairness, that's enough. Now, in my submission, the only unfairness that can be objective is procedural. General unfairness, with respect, is always subjective. It's impossible, in my respective submission, to define general unfairness in an objective sense. Now, if the Secretary of State is able to say, for instance, in this case, that, well, there is general unfairness, that this person who is alleged to have done fraud will get away. Now, what stops a person who is facing deportation with British citizen children to say that, well, admit my evidence, because it is unfair to my children. They haven't done anything wrong. And in a general sense, there should not be any unfairness towards them. So in my submission, the only it's not enough to say that, well, there is objective general unfairness and that's enough to admit new evidence. But this point is essentially tied with the first point that my learned friend made. She says that, well, there is objective unfairness because the Secretary of State is effectively tied to this decision. She's bound by it, she can't do anything. But that submission is wrong. Well, these are my submissions on the law. May I now make brief submissions on the facts and the decisions made below?
Yeah.
Now, my lords and my lady has, of course, seen the reference to the judicial review judgment. May I start by taking you to that judgment? You have that judgment in the supplementary bundle. It's the first document, starts at page 1. Page 1 is the order that the judgment starts at page 3.
Just bear with me, I don't have a supplemental one that should be online.
It's in the back of the
If you
main
look
bundle.
at
Oh,
the
that's
main
where it is,
bundle,
that's right, it's
behind
the second part of the
tab,
core, isn't it?
Mhm.
Thank you
the
very much.
supplementary
Got it.
bundle starts behind the
Thank
tab.
you, thank you.
Yes.
Got
So
it.
page 3 of that bundle.
Got it.
Okay.
So that was a judicial review challenge to the earlier decision to refuse the application for indefinite leave to remain. If you look at paragraph 4, the applicant, the appellant now, was arguing that, well, the respondent has failed to prove that he was dishonest. Secretary of State argued at paragraph 5 that it was not for the upper tribunal to decide whether the appellant was dishonest. The Secretary of State referred to Giri. Giri is a case where this court said that at a judicial review claim of this nature, the upper tribunal, the judicial review court, would make no findings of fact. A challenge is limited to rationality grounds. The Home Secretary, as is clear, insisted that that judge should not make any findings of fact, and the judge made no findings. The judge concluded, without, of course, hearing any evidence, that the Secretary of State's decision was rational. It fell within the range of reasonable responses. This is paragraph 16 of the bundle. Paragraph 16 of the judgment. The Secretary of State acted reasonably, and conclusions were open to her on the evidence. No findings, simply that the Secretary of State acted rationally. The appellant then makes a human rights claim. Again, a human rights claim is what has happened is not unique. The Secretary of State makes a decision alleging dishonesty. The only course of action is judicial review. Judicial review is unsuccessful. The person then makes a human rights claim. This is all in accordance with the case law of this court, that if you want findings of fact, make a human rights claim and let the tribunal decide what to do. The human rights claim is refused by the Secretary of State. You have that decision at page 87 of the bundle. And the relevant parts of the decision are at page 88. We'll see that the Secretary of State says that the appellant was claimed to have worked with a company, and the Secretary of State said that, well, I have evidence that shows that, well, that company was shamed. Not the appellant's business, not the appellant's company, but a company for which he said that he worked for. No reliance is placed on any documents as such. There is reference to letters from the accountant, and bank statements, it seems, in the fourth last paragraph of page 88, that monies went into went into a director's account. No reliance is placed on the judicial review judgment for good reason, which is that there's nothing in the judicial review judgment that was of any assistance. There were no findings of fact. So the appellant files an appeal to the tribunal. So when I showed my lords and my lady the relevant rules, I demonstrated that when appeal is filed, the notice of appeal is then served on the respondent. And the respondent then looks at the decision, looks at the notice of appeal, and she had 28 days to file her evidence, her case in response, to tell the appellant and the parties the documents on which she seeks to rely on. Absolute obligation under the rules to do that. So that was the first opportunity for the Secretary of State to tell the appellant and the tribunal the documents on which she seeks to rely on in these proceedings. So that wasn't done. The matter then reached the first tier tribunal. Page 82 of the bundle is the first tier's decision. You'll see that the Secretary of State was represented. Now, under the rules, so you file, the respondent files their documents, then there is a hearing, and the parties would file the bundles and evidence ahead of that hearing. The second opportunity for the Secretary of State, if you wanted to rely on any of those documents, was to submit documents prior to the hearing. Now, you'll see that at the outset of the hearing, the issue was flagged that, well, the Secretary of State has adduced no evidence to support the allegation of dishonesty. This is paragraph 9. If the Secretary of State at that point could have said that, well, I have this evidence, I'm adducing it now, or could have said, well, I have this evidence, I don't have it with me now, please adjourn the hearing and give me an opportunity to adduce that evidence. So she was represented, made no adjournment application, adduced no evidence. But that is not all. The appellant gave evidence. He said that, well, he hasn't done anything wrong. The respondent cross-examined him. Paragraph 10 of the judgment, page 84. The respondent decided not to challenge the appellant's evidence. So the respondent knew what was said in the decision letter. She had the evidence in her possession. She made a decision not to challenge the evidence. So that is the first point, irrespective of a failure to provide documentary evidence. The respondent could have asked the appellant, well, what you're saying in your statement, my friend has asked for a copy of the statement to be put in the bundle. You have that bundle. The Secretary of State could have said, well, I don't accept your witness statement. You're lying. You're making it up. You know, you were a fraud, or the company for which you have worked was fraud. So no questions were put. And then this is the first point the judge makes, that there is no challenge in cross-examination. The second point the judge makes is that, well, in any event, there isn't even any documentary evidence that is provided to substantiate that allegation. No other decision. The judge could not have made any other decision but to accept that the respondent has failed to discharge the burden of proof. The burden of proof, it is common ground, was on the Secretary of State. Now, at paragraph 4 of the judgment, you'll see a reference to Balaji Gari and Ahmed. Not sure if the court is familiar with the authorities, but the sort of basic point that was made by this court in Balaji Gari was that where the Secretary of State wants to refuse an application on grounds of dishonesty, she must follow the minded to refuse procedure. She must give an opportunity to the applicant to comment on the evidence or the allegation. But no such opportunity was given when the earlier application was refused, and this is again this is not a unique case. And so the earlier application that was refused, no minded to refuse procedure was followed. It's perfectly understandable that the Secretary of State in those circumstances decided not to rely on anything that was said in their decision or in the judicial review proceedings. But that was the Secretary of State's choice. So this decision was issued on 28th of October 2019, page 81 of the bundle. The Secretary of State was successful, the appellant was successful on one ground, the Secretary of State was successful on another. It's on the ground on which the Secretary of State was not successful. In my submission, it was an option, not an obligation or a duty, but an option to seek permission to appeal, to say that, well, the first judge got it wrong. There is actually new evidence. That evidence shows that that decision is wrong. But the Home Secretary decided not to challenge that decision, not to say anything about it. The appellant applied for permission to appeal. Permission was refused.
The Home Secretary couldn't appeal, could they? Because they won overall, hadn't they? Was it open? Are you saying it was open to the Secretary of State to appeal
Yes.
against the dismissal by the FTT? How would that have worked?
I mean, this is not, and of course, I want to focus on the issues that matter, but there is quite a lot of case law on the subject. I mean, if the point is, I mean, when I was reading the papers yesterday, I thought that someone will ask this question.
There you are. You were right.
And I have a recent judgment of the upper tribunal, which reconciles all.
I think you're right. In a sense, it's a bit of a sideline, isn't it? Because in the end, it all does get to the upper tribunal.
Yes.
But you say there's authority to say that the Secretary of State can appeal even though they are the successful party on an appeal.
Yes. So the authority in short says that a party who has achieved the exact outcome that they wanted to achieve cannot appeal. But where a party is successful on one ground and unsuccessful on another, then that party can appeal to the tribunal. When I showed the court the provisions in the 2007 Act, it said a party may appeal, not that an unsuccessful party may appeal. It's not something that is a live issue in this case. So when the position is that when in a case of this sort, a party is not happy with the decision, they can appeal, or they can wait to see what the other side has done. If the other side has appealed, they can put in a Rule 24 response seeking permission to raise the additional ground. And this is what the Secretary of State ultimately did. But it was an option in my respective submission in 2019 to do something about the decision. This is relevant because of the time she took to take this point.
Yep.
So first year tribunal refused the appellant's application on 2nd of March. The Secretary of State received that decision. Another opportunity for for the Secretary of State to look at the matter, take the point she wanted to make. Then an application to the upper tribunal by the appellant. That application was refused too. It's page 76 of the bundle in April 2020. Another opportunity for the Secretary of State to review the matter. There was then a court judicial review as it was then known. So the appellant had to go to the High Court to persuade that he had a real prospect of success. The judge was wrong to dismiss the human rights appeal. So the High Court quashed the upper tribunal's decision, and the upper tribunal granted permission to appeal on 30th of August 2021. The relevant date, 30th of August 2021.
It's page 75.
Page 75. So when I showed you the rules you'll recall that Rule 24 said, well, file the respondent's notice. You must file the respondent's notice. Must, if you want to challenge the decision on some other basis. You must file it within 1 month. Within 1 month. The matter then was listed for a hearing at the upper tribunal. And shortly before that hearing, the Secretary of State submitted the Rule 24 reply, way out of time. If you want to know the date on which it was served, this is paragraph 10 of the upper tribunal's decision, 11th of October 2021. So 11th of October 2021. And the Secretary of State then sought to rely on the evidence that you have seen. The upper tribunal's decision starts at page 57 of the bundle. You'll see that the upper tribunal agreed with the appellant that the first judge made an error of law in dismissing the Article 8 appeal. That was plainly the correct conclusion. There's no challenge to that. But she also effectively crossed appeal by way of an out of time Rule 24 response. The discussion starts at page 66 of the bundle. And you will see that the judge was satisfied. This is paragraphs 19 to 21, that the first judge made an error in dismissing the appellant's appeal. The discussion about the cross appeal commences at paragraph 22. And you will see citation from E&R at that paragraph. Paragraph 23, the judge refers to paragraph 92. It's now common ground that that is the wrong paragraph. Then look at 25. You'll see a discussion as to the Laird and Marshall principles. Those principles were not met. The evidence was available at the date of the hearing. It was not brought to the first year tribunal's decision. And so Laird and Marshall test is not met. The upper tribunal then says that, well, the appellant was aware of the allegation, was aware of the evidence. And it is surprising that he made no reference to that evidence in the witness statement and made no attempt to address that evidence. Now that analysis, in my respectful submission, runs contrary to the scheme of the procedure rules to which I've taken you to. The burden of proof is on the appellant. He's not required to help the Secretary of State to prove an allegation against him. He appeals against the decision. The Secretary of State then, under Rule 24, has to tell him and the tribunal the evidence on which he seeks to rely on. That may well include judicial review proceedings, judicial review judgment, or the evidence that you now have. There is no obligation on an appellant, in my respectful submission, to adduce evidence that he knows about, but is not placed before the tribunal. I mean, this, if you follow this analysis, I mean, this will, in my respectful submission, lead to a completely undesirable, unworkable situation. I mean, this obviously works both ways. I mean, what if an asylum applicant then says that, well, an asylum claim is dismissed, the applicant comes up with a newspaper article that wasn't adduced below and says that, well, it was in the newspaper, or some other objective evidence. The Secretary of State ought to have been aware of it, No, I want to rely on it because it is surprising that the Secretary of State made no reference to it, made no attempt to engage with it. The evidence that no one had used. I mean, it will work. It work both ways. The point that I respectfully seek to emphasize. So to extend Laird and Marshall on that premise, in my submission, is not principled, and that may well lead to consequences that the Secretary of State would not call for. And as I said, the way around the position that the Secretary of State says she's in is twofold. Rather than seeking to extend Laird and Marshall, which applies in my respect, which would extend to all cases. I'm not saying, making no concession that she should do that, but why not simply say that, well, I now have this evidence, I'm refusing to implement the first judge's decision. Or just go back to the first judge and say that, well, the appellant misled you. Why don't you just set aside that decision? But to bring an appeal to the upper tribunal on that basis, in my respective submission, is not the way forward, and that cannot in my respective submission amount to an exceptional circumstance that justifies departure from Laird and Marshall. Paragraph 26, the judge, the upper tribunal judge says that the first judge cannot be criticized because the evidence was not brought to her attention. And the judge then says that, well, there is unfairness. And this is where, in my respective submission, there is a real difficulty in that approach. So if you look at the middle of paragraph 26, the judge says, I'm satisfied that there was unfairness. I do say that there wasn't any unfairness, but see what the judge then says, that, well, the unfairness arose because of the conduct of the respondent who had failed to provide the tribunal with the underlying evidence, and she's responsible for the error. But the question as to whether the respondent was at fault was relevant to whether there was unfairness. So what you can't do in my submission is to say that, well, there is unfairness, and then considers the respondent's conduct subsequently. If one considers the circumstances focusing on the respondent's conduct and the scheme of the rules, the conclusion that one comes to in my respective submission is that there was no unfairness. The Secretary of State had at least 5 different opportunities to challenge the appellant's evidence.
Is the unfairness that's being referred to here the unfairness of the FTT proceeding on the basis that dishonesty was an unsubstantiated assertion, when the fair position would have been that it had at least been considered on a judicial review without findings? I take that point.
Yes.
And isn't it adequate to say, well, look, that's what's gone wrong here, but I now need to look at why it's gone wrong, and that's where all the factors that you're referring to come in. So whose fault was it? What opportunities were there to remedy it? All that comes in. But isn't it acceptable for a judge to say, look, this is the problem. There has been an unfairness because the FTT plainly didn't have the full picture. But I now have to look at what I do about that and why that has come about. Is that not an acceptable way forward?
Lady, it is. I don't contest that. But what I do submit that in deciding whether there is unfairness, you simply don't look at the mistake itself. That why the first judge was not provided with all relevant documents. In deciding whether there is fairness, you look at all the circumstances, you look at the conduct of the parties, you look at the scheme of the rules, and you then decide whether there was objective unfairness, if you're not with me on the points that I have made. So my submission is that a finding of unfairness cannot be made without considering the matters that I have highlighted.
Isn't the, I mean, I follow your point about unfairness, Mr. Malik, but it isn't part of the problem you face what the judge goes on to find in paragraph 28, which is that Land Marshal can be departed from in exceptional circumstances.
Yes.
And she then goes on to deal with why these are exceptional circumstances,
Yes.
and says that, in effect, there was fault on both sides, but that your client can't, as it were, be completely excused for failing to raise matters of which he was aware, in relation to which there may not have been findings of fact, but the fact is that the reasoning of Upper Tribunal Judge Perkins was pretty strong meat, if I can put it that way.
Yes.
And the judge here is simply making the point that this is exceptional because, she says, if Judge Black had been aware of all this, she would have taken a different line.
Yes.
Therefore, there has been an error of law in relation to the Land Marshal point.
Absolutely.
So it's that it seems to me, at least, is the hurdle you've got to overcome.
Yes.
Either by saying, well, this doesn't apply at all, as it were. There are no exceptional circumstances. Well, I think that's what you have to say.
So that's what I do.
You have
do
to say
foresee.
there are no exceptional circumstances.
I completely recognize that unless I'm able to persuade the court that there's something wrong with paragraphs 28 and 29, I may well not succeed. And I'll come to those paragraphs just
Sorry,
in a
I'm
minute.
taking you out of that, of course. I didn't mean
But
to
you
do
have my submissions on paragraph 26 and why that is wrong. But of course, I don't win this appeal simply by saying that the judge has not dealt with the matters in the right order. I'm simply seeking to respond to the point that lady made, that whether you consider unfairness first and then all other matters.
Yeah.
But we have my submission that it all wraps up in unfairness. Now, if you then, and I do submit, as I have to, that there wasn't any unfairness in this case that justified departure from Land Marshal. I do submit that. But my, of course, the point that I make before coming to that submission is that the way in which the judge has dealt with the issue of fairness isn't in accordance with the law. If you then look at paragraph 27, before I take you to paragraph 28, now, irrespective of whether the evidence is admissible to establish a mistake of fact, there's a serious issue that this evidence on any view was way too late. I mean, even for a Rule 24 response, it was too late. And you'll see that the judge there accepted that that there has been a delay. Rule 24, the Rule 15 says that the tribunal will consider any unreasonable delay. But the point is that the appellant is not taken by surprise. I mean, that with respect is not the proper approach to consider non-compliance with the rules. You don't simply ignore the rules on the basis that the other party was not taken by surprise. You have to apply Denton approach. There's a 3-stage test: whether the delay is significant and serious, what is the explanation, how the discretion should be exercised. So it's not enough, wasn't enough for the upper tribunal to simply say that, I'm accepting this, although it's way too late, simply on the basis that the appellant was not taken by surprise. To accept that analysis, in my respective submission, would be entirely inconsistent with catalogue of cases from this court as to the procedural rigor that applies in these proceedings. Is it open to an appellant? I respectfully invite Lords and Bellady to consider, come up with a new evidence shortly before the hearing, or file an appeal way out of time, and to say to the judge, the respondent is not taken by surprise, it's all in public domain, or the Home Secretary is ought to be aware of it, admit my appeal or evidence out of time on that basis, that would surely be objectionable. So there is in my submission an error in paragraph 26, there is an error at paragraph 27. You then go to paragraph 28. In my respectful submission, there is an error in the first sentence. The judge said, well, Laird and Marshall is the starting point. It's not the starting point. It is the test that the judge had to apply. It is the starting point for the purposes of paragraph 92. So when I showed you paragraph 92 of E and R, so when there was a system of review, the tribunal could have ordered a rehearing, then Laird and Marshall was simply a starting point, merely a guide. But on an appeal to this court, Laird and Marshall is the test. But like any other court or tribunal, one can depart from it in exceptional circumstances. Now,
So hold on.
Oh, hang on, yeah.
Everybody's speaking very fast. That's quite an important caveat, isn't it?
Yes.
So the Laird and Marshall test of whether the evidence was available, and, all the stuff that's quite familiar. There's always been an exceptional circumstances
absolutely.
part of it, hasn't there? As
Absolutely.
part of the test that the court always has discretion in exceptional circumstances to admit, doesn't it?
Absolutely, but you got in my respectful submission, a judge must recognize that Laird and Marshall is the test. It is the test that applies, but there is a discretion to depart from it. It's not merely a starting point. It's not a starting point, as the judge said. I do say, as my lord said, that well, there were no exceptional circumstances in this case, because if I don't make that submission, I of course lose. Now, in deciding whether there are exceptional circumstances, in my submission, the court, in principle, should apply the same approach that this court would apply on an appeal from the upper tribunal. So how would this court treat an appeal by an appellant who is unsuccessful to this court, who now adduces fresh evidence and says that, well, there is general unfairness, I have children.
This court, you can put it that way around, that an appellant had lost, and let's say somewhere in the papers known to both parties there was some exonerating material. So let's say an appellant had been found to be dishonest by the FTT, upheld by the UT, and there was in fact some exonerating material, some powerful exonerating material that hadn't been put before the UT. I suspect this court would be likely to do exactly the same thing. It's not right to say it's a one-sided remedy. I suspect this court would have in very clear focus just wanting to get the right answer and ensure that the justice of the case was met.
Yes, but will you do the same? I respectfully invite my lady to consider, if the appellant had that evidence on his possession all along, decided not to adduce it, the Home Secretary presented a witness, decided not to challenge that witness by cross-examination, then it had 10 or 5, just giving example of this case, 5 opportunities to adduce that evidence, and it wasn't adduced. All that, in my respectful submission, would lead to a principled conclusion that it is not right to set aside the decision made below on that basis. Yes, and in deciding, whether or not there are exceptional circumstances, well, this court surely will consider the legislative scheme, the way in which the rules operate. Rule 24 in particular, the court will consider the timelines, what happened at the hearing, whether there was any evidence, whether there was any oral evidence, and whether it was challenged. The judge then makes the point at paragraph 24 that, well, there are exceptional circumstances, essentially because the appellant, who was aware of this allegation, decided not to refer to it in his witness statement or in the evidence. Well, this is, in my submission, reversal of burden of proof. It's not about duty of candor or disclosure in this context. It's effectively a reversal of proof, reversal of burden of proof. The judge expects, in my respectful submission, for the appellant to help the Secretary of State to prove that he's dishonest. And it's quite contrary, in my respectful submission, to the scheme of the rules, to the authority, to MHEJ, that I have I have taken you to. So the question that you'll ask yourself, that, well, the appellant filed a notice of appeal. The respondent had not filed a response, a Rule 24, a Rule 34 response with providing further evidence. Is the appellant not entitled to proceed on the basis, as M had said, that the Secretary of State is not seeking to rely on that part of the decision? So the point that the judge made at paragraph 28 with respect is not a good point. I do submit with this respect that the appellant was not at fault. If there was a party at fault, it was the Secretary of State. The appellant was, and the judge says that, well, the appellant has not, that no explanation has been provided as to why the appellant has not mentioned this in witness statement. You have the explanation. The appellant was not required to do that. Provided that explanation to the judge by reference to MH and the relevant rules. You'll then see from paragraph 9, the judge said that, well, this new evidence probably would have had an important influence. How that is consistent with paragraph 66 of E&R, I asked the court to consider. Paragraph 66, or Justice Conworth said that, well, the evidence should be uncontested in the sense that it establishes a fact, paternity, nationality. And if, so it's not enough to say in my respectful submission that, well, the evidence will have an important influence, and for that reason, it is admissible. The judge then refers to the judicial review judgment. Well, two points that I make about that at the risk of just repeating myself. The first is that the judicial review judgment was not relied upon by the Secretary of State either in the decision or provided to the tribunal in accordance with the rules. So the appellant was perfectly entitled to proceed on the basis that the respondent was not seeking to rely on it. And secondly, in any event, when I took you to that judgment, I demonstrated that there were no findings of fact. In that case, there was no live evidence. The upper tribunal simply submitted that the evidence that the respondent acted rationally. The judge says, well, it's not. The evidence is apparently credible, but that's not enough. The judge said, well, in the wider interest of the justice, I would admit the fresh evidence. There's no principled basis to admit the evidence on that basis. If that is an exceptional circumstance in my respectful submission, that would apply both ways. Then look at paragraph 30. You'll see that the judge exercised, assuming that I'm wrong about everything that I've said so far, the judge exercised the discretion by reference to paragraph 92 of E&R. I acknowledge the importance of principle of finality, but guided by paragraph 92 as to the exercise of my discretion. But that is plainly wrong. So even if I'm wrong about everything that I've said so far, the judge exercised the discretion on the wrong footing, and unless the court is satisfied that there is no room for a different outcome, on any view, a judge, on no legitimate view, a judge could have declined to admit this evidence. This court should set aside the upper tribunal's decision. Now you have made the point that, well, this is persistent non-compliance with the rules. Even the fresh evidence, even if it is admissible, it was still way out of time. It did not comply with the time limit in Rule 24. The judge simply ignores all that. And what about the point that I have made? Well, irrespective of this evidence, the Secretary of State's advocate at the trial decided not to challenge the appellant's evidence. For these reasons, I submit that there isn't, it wasn't, the conclusion reached by the judge was not open to him even on the test that he has identified. The decision is flawed, and if this court concludes that there is an error in the decision, to recognize that I'm perhaps repeating myself, but there is a room for a different outcome, that one judge, considering all the factors that I've outlined, may arrive at a different conclusion. It would be appropriate to simply to allow the appeal and let another judge decide what to do. I mean, whether or not, and it is at least questionable. I'll leave it to my lord and my ladies to consider that the judge remitted the appeal to the first year for a rehearing, and it is at least questionable as to whether in the circumstances it was appropriate for the judge to make that decision for himself, to admit evidence, instead of just leaving it to the trial judge at the there's going to be a rehearing at the first year tribunal in any event, pursuant to this judge's decision. And if the Home Secretary seeks to rely on new evidence at that hearing, maybe it is a matter for that judge to consider whether there are exceptional circumstances, or whether it is appropriate to allow the Secretary of State to make the point. The Secretary of State may then provide an explanation for her omissions, failure, delay, and let the trial judge to decide what to do. Yes. So unless I can assist you any further, I think these are my submissions in opening.
We will rise for a moment.
Court rise if able.
Yeah, okay.
Extra cups.
Yeah, you just take one of those.
Excuse me.
Another jug, water.
I'll fill it up.
Get
Yeah, you can just.
you can use that.
Not sure. Yeah, there's a glass.
This is. It's not that sort of crazy. No. I guess. Basic is that it was period in upbringing.
I'll let them know. Yeah, thank you.
That's where does it stop? There's no one having a burden of proof. There is no burden. There's a actual burden. There's a burden of proof. Yeah. Just I would say it's the principles of animal justice and punch up and required to incriminate oneself. Exactly. And they were sort of quite alright on that. But that's really the only point. The JR decision is not being controversial. It's not the time. If there's something exonerates, yes, if there is a sentence in the file which says he's been convicted, something like that, yes, but not mentioned if which are not looking at rationality before the minded process was around. Pre-biology gap. Yeah, so this is and what about 24 to 34 goes out to 30 exactly. There's no one having procedurals. And this besides the same statement also because appellants are more likely to use this system to throw at the court further evidence. Yeah. That have the conceivable evidence, that is. Yes. Suppose there's a finding of conditions of genuine and subsistent, right? The judge says that you will go back and you can continue with this evidence and throw it and say, there's strong evidence that it is. Where does it stop? Exactly. Photographs. So I was passing through the airport and the immigration officer asked me this question. But I want to tell you that I keep going to give an answer which is potentially not correct, but I'm just bringing it to your attention. Exactly. You also cause problems for the parties in terms of how to they prepare for the case.
All rise if able.
This was what?
My lord, my ladies, my skeleton argument appears at page 16 of the core bundle. In summary, the respondents' submissions are, for ground one, that the upper tribunal judge did not err in admitting the evidence of dishonesty. The judge was not required to apply strict Ladd-Marshall principles without modification. The correct test was Ladd-Marshall, which could be departed from in exceptional circumstances where the interests of justice required it. I think we are agreed on that. And secondly, that if the upper tribunal judge did apply a more permissive test, and it's not accepted that he did, but if he did, then any error wasn't material, given the exceptional circumstances in this case and the interests of justice.
Yeah.
In respect of ground two, the submissions are, well, I should say my learned friend's case is that there was no unfairness because of the Secretary of State's conduct, and that the evidence, the fresh evidence, is not uncontentious. And in response, the submission is that unfairness does not rely on the fault of the parties. And it arises in this case because the respondent, who had been dishonest in both his application for leave and before the first tier tribunal, could obtain indefinite leave to remain in proceedings because of a preserved finding, which is demonstrably false. And as to the contentious nature of the evidence, the respondent's position is that, and I think my lord has the point, that the evidence is pretty weighty from the judicial review judgment, but that in any event, the issue is not whether the dishonesty itself is uncontentious, but whether the availability of the evidence itself is uncontentious. And we say that it's beyond dispute that there was evidence of the dishonesty. Before I address each of those grounds, I'd like to take the court briefly through some factual matters that I have in mind, of course, that the court has been taken through a great deal by my learned friend. Following submissions on the facts, I will then turn to each ground of appeal and try my best to deal with the arguments raised, some for the first time by my learned friend in his submissions this morning. But there may be some matters on which I would ask for some additional time to respond, but I'll come to that when I deal with each of the grounds. But before dealing with the facts, I would like just to draw the court's attention to the unusual context of this appeal. Whatever the outcome of this appeal, there will be a rehearing in the first tier tribunal. The appellant has secured a remittal to the first tier tribunal, owing to an error of law regarding the interpretation of the case of Asylum. And so this appeal concerns a decision of Upper Tribunal Judge Mandalia to decline to preserve the findings relating to dishonesty. And so, in a sort of typical case, if I can put it that way, the court's deciding whether, on the one hand, the interests of finality are outweighed by the interests of justice in a particular case. Here, because of the unusual context, there is no question of finality. The question is whether at a rehearing, the tribunal will be bound by findings which are demonstrably false in my submission. And if I could just at this stage ask the court to turn to page 84 of the bundle, the core bundle.
Yeah.
This is the judgment of the first tier tribunal judge, Miss Black. And the preserved finding is at paragraph 10. And it includes that the respondent failed to produce any documentary evidence to support the allegation, that the previous application was based on false information. And then the penultimate sentence, the basis of the refusal in terms of the appellant's undesirability amounted to an unsubstantiated assertion. And I know my lady has noted that already in her observations to my judgment. But that is the preserved finding, that it's unsubstantiated. And that is definitely, we can say beyond doubt, not correct.
I thought the preserved finding was the last sentence. I'm satisfied the respondent failed to discharge the burden to show that the appellant had been involved in deception in previous applications. So that was what the appellant was arguing here, that you couldn't go behind that in the renewed hearing.
Well, my lady,
Doesn't matter perhaps, but
It doesn't matter, does it?
it's all part of the same thing.
yes, the reason it's not discharged is because it was unsubstantiated, I would say. If I can just very briefly take the court to the judgment of Upper Tribunal Judge Perkins in the judicial review. My learned friend took the court to it briefly. It's in the supplementary bundle and appears at pages, I think begins at page 4, but I'd like to draw the court's attention to page 5. And paragraph 9, where the judge sets out the evidence that he'd been particularly assisted by. He says, I've been particularly assisted by a report relating to Operation, I think it's pronounced Kudgong, which is essentially a report of forensic accountants taking into account the business activity of IWIN and its associated entities. And I pause there to say that the report itself appears at page 131 of the supplementary bundle. And I don't ask the court to turn to it, but for the, my lord, for your note, the passages upon which the respondent relies in particular are at page 214 and 223.
Sorry, give me again.
214 and 223. Those are the page numbers of the supplementary bundle.
Okay.
And there is also a summary report concerning the appellant at page 247 of the supplementary bundle. And so returning to the judicial review judgment. Judge Perkins quotes a passage from the forensic accounting report, which is that their conclusions are that the companies and entities involved were a sham and utilized to facilitate the fraudulent applications by the named individuals and the abuse of the Tier 1 process. And the judge notes at paragraph 10, I note immediately that this applicant is not one of those named individuals, and that's in the Kudge-Gong report. But I also note that it is the conclusion of the report that the companies and entities were a sham, not that they were involved in a scam, but that they were a sham. And that is their whole reason for being was dishonest. And that was the conclusion of the forensic evidence before the Secretary of State. And the judge goes on to deal with the submissions put forward by this appellant in those proceedings at paragraph 12. He says, Mr. Lewis argued that there is evidence that there was legitimate business activity, and with respect that is exceedingly thin. The best that it gets is a recognition in the forensic report that at the material time the business declared a turnover and a profit to the revenue, Of course, it does not follow that that declaration was based on legitimate trading. It merely means that it was made, as pointed out by Mr. Metcalf on behalf of the Secretary of State. On its own terms, that is a very unsatisfactory assertion because at the time when a turnover of profit was declared to the revenue, a much more substantial sum had been paid by way of consultancy fees, allegedly, to the applicant. So on the applicant's own figures, the turnover cannot be right. There is really nothing in that slim piece of evidence to support any view that there was any legitimate business activity going on. And it's on that basis that the judge found that he was entirely satisfied that it was open to the Secretary of State to conclude that this was a sham business and that the applicant had been involved in dishonesty. The judicial review bundle appears behind tab 2 of the supplementary bundle. And so this is the evidence that the appellant had filed in support of his appeal. And it includes HMRC records that he relied upon.
Yeah.
And behind tab 3 is the material that was relied upon by the Secretary of State.
Mhm.
I'm not asking this court, of course, to make findings about that. But the point is that there was overwhelming evidence in my submission of dishonest activity, which the appellant had seen, obviously, had responded to with evidence of his own. And there had been a full hearing, albeit it was a judicial review hearing, in which the judge held that there was nothing to support any legitimate business activity in those entities. And so it is, in my submission, inconceivable that a judge holding a fact finding would have come to a different conclusion. But more importantly, it's clear that the appellant knew very well what the basis of the allegations of dishonesty were.
Well, in a sense, that point works both ways, doesn't it, Ms. Bottle? Because you say there was overwhelming evidence of dishonest activity. That makes it all the more astonishing that the Secretary of State didn't put that material before the first-tier tribunal.
Yes.
There's no explanation provided at
There's-
any stage as to why that was the position.
and there isn't an explanation that I can put forward.
No. Very frank.
There's not very much else I can say.
No,
I'm
I
afraid.
don't think there is. Okay.
Behind tab 4 of the supplementary bundle, there's the appellant's witness statement
Yeah.
in these proceedings.
Sorry, I haven't got tabs, but
Oh,
what's
it's
page number?
252.
Okay, thank you.
And I draw the court's attention to this document because there has been a lot of discussion by my learned friend this morning and in the judgment about where the burden lay between the parties of disclosure. But in my respectful submission, looking at this statement, it's not just that the appellant doesn't make reference to the judicial review proceedings, but in my submission, he positively misleads the court about what he knew. And I rely here on paragraphs 9 and 14 of this statement. So he says that it's important that I'm aware of the case against me and that all material documents are disclosed properly. And then there is no material evidence against me that I acted fraudulently. Well, he knows that there is because he's seen it and disputed it in the judicial review proceedings. And again, at paragraph 14 of the statement, he says again, I believe that it's important that I'm aware of the case against me. So this goes further in my submission than failing to draw material against his interests to the attention of the tribunal. But he is in fact misleading the first tier tribunal judge by making those statements.
Well, you say presumably the paragraph 9 really can't, as it were, there's in the light of what Upper Tribunal Judge Perkins had said, that paragraph is positively misleading.
Yes.
And if the appellant were being full and frank, he would have said there were the following allegations. There were findings made by Upper Tribunal Judge Perkins, and my answer to that is as follows.
Yes. Or even, being more generous to the appellant, he could have said that it's not true and left it there.
Yeah.
But saying that he had not seen the case against him, that was materially misleading.
He does say, I mean, it's pretty weighty to say that he's misleading the court here, but I have to confess I'm a bit uncomfortable with that, but anyway, that's your submission. He is quite entitled to say, isn't he? I don't accept that I acted fraudulently, and I don't think the SSHD has got any evidence to prove that against me. He's perfectly entitled to say that, isn't he? So doesn't
I think
your accusation against him is to say he's not aware of the case against him is a bit disingenuous because he's been through a whole JR.
Yes. Yes, and I think he's entitled to say that he didn't act dishonestly, it's not true. But I would also say his statement that there is no evidence, I think that is misleading.
There's no material evidence against me. I mean, he doesn't know that your predecessor is going to poll up to the FTT and not even mention judicial review. At the point that his witness statement goes in, he might reasonably be anticipating that there is going to be quite a dust-up in the first tier tribunal about whether he was dishonest or not.
Well, I wonder.
Well,
because
he knows that it's happened, doesn't he? So anyway, I take the
Yes.
point, but I suppose I just want to,
maybe
I
he's
put down my own thought on para 9. I think that,
yes. Well, then I think I would. The court has my submission, but perhaps my lady is right to focus on the sentence or the phrase that I'm aware of the case against me. Perhaps that's a clearer example of what I'm trying to convey.
Yeah.
Turning then to my submissions on each of the grounds. Beginning with ground 1, I was going to focus on whether Ladin-Marshall principles and the strict test were what the FTT should have applied, but I think my learned friend and I are agreed now that it's paragraph 91 of that judgment, and so the test...
The real issue, as I see it at least, is whether it... true it is that the judge has focused on the wrong paragraph of ENR, so to that extent there's an error. But does it actually make any difference? Because she doesn't suggest, I don't think, that the exceptional circumstances test differs depending upon the extent to which the Ladin-Marshall principles would otherwise apply. So where you get to is, as it were, the right result, but for the wrong reasons.
Yes.
And therefore it doesn't matter. I mean,
Yes.
I think that's...
Yes, I would only add that it's not accepted by the respondent. I mean, it's beyond doubt that he quoted paragraph 92, but it's not accepted that he necessarily applied the wrong
Is it
test.
a he or a she? I keep on saying she. But
It's a he.
is it a he?
Yes, it's a he.
Thank you. Yeah.
So, and I'll take the court through the judgment in a moment to set out, what phrases I rely on in that contention. But it's not accepted that he did apply the wrong test. But even if he did, yes, as my lord notes, the submission is that it could have made a difference.
Okay, thank you.
But if I can first then take the court through E&R, there's just a few points I'd like to make,
Yeah.
and that appears at tab 3 of the authorities bundle.
Yeah.
And so my learned friend has already taken the court through it and explained the background, but of course it's an appeal against a decision of the IAT on the basis of evidence which had become available after the hearing, but before the decision was handed down. And the Court of Appeal was concerned with rationalizing the authorities on when fresh evidence could be admitted, but also whether there was an error of law, which was a mistake of fact, or whether that was not a ground of review. And there's quite a detailed discussion by Lord Justice Carnwath of the authorities on both points. And I'd just like to draw the court's attention in particular to the court's handling of the judgment of Lord Slynn in the CICB case. And that appears at, begins at paragraph 45. So the court here is considering whether a decision reached on an incorrect basis of fact can be challenged on an appeal limited to points of law. And Lord Justice Carnwath says the debate received new life following the affirmative answer given by Lord Slynn in the Crown and Criminal Injuries Compensation Board. In that case, the claimant had claimed compensation on the basis that in the course of a burglary, she had been the victim of rape and buggery. She was examined 5 days after the burglary by a police doctor who reported that her findings were consistent with the allegation of buggery. However, at the hearing of her claim, that report was not included in the evidence, and the board was given the impression by the police witness that there was nothing in the medical evidence to support her case. The claimant did not ask for the report, but in Lord Slynn's words, having been told that she should not ask the police for statements as they would be produced at the hearing, it would not be surprising that she assumed that it would be available, in effect.
Yeah.
And one of the, what I'd like to draw the court's attention to here is that, of course, evidence which was available, but which the appellant herself bore the burden of providing, albeit there was some sympathy that she would necessarily expect to have provided it. But she was if I could put it this way, at fault in a broader sense for not putting that evidence forward. In that case, there wasn't a duty on the police, of course, to provide that material before the board. And if I can draw the court's attention to paragraph 47, this follows the judgment of Lord Slynn. In the case of the CICB, he preferred to decide the case on the alternative basis that there had been a breach of the rules of natural justice amounting to unfairness. He said, "It does not seem to me to be necessary to find that anyone was at fault in order to arrive at this result. It is sufficient if objectively there is unfairness. Thus, I would accept that in the ordinary way for the applicant to produce, that it is in the ordinary way for the applicant to produce the necessary evidence. There is no onus on the board to go and look for evidence, nor does the board have a duty to adjourn the case or further inquiries if the applicant does not ask for one, and nor is it the duty of the police to go out and look for the evidence on particular matters." And the conclusion of Lord Slynn in that case was to allow the appeal. And I should say, though he decided it on the question of natural justice, he did accept that there was jurisdiction to find an error of law on the basis of a mistake of fact. And this decision of Lord Slynn is what Lord Justice Carnwath bases his conclusions. And I can take the court to paragraph 63 of ENR. In our view, the Criminal Injuries Compensation Board case points the way to a separate ground of review based on the principle of fairness. It is true that Lord Slynn distinguished between ignorance of fact and unfairness. However, we doubt if there is a real distinction. And the decision turned not on issues of fault or lack of fault on either side. It was sufficient that objectively there was unfairness. And unfairness arose from the combination of 5 factors. And I pause there. I will, in due course, go on to my learned friend's submissions about fault on the part of the Secretary of State. But here's a clear authority for the proposition that the question of unfairness does not depend on matters of fault. It is a question of objective fairness. And in this case, as my lady has noted in her observations, the unfairness relied upon is the binding of the first-tier tribunal judge to a finding which is not true. But before I go into that, the last passages I wanted to draw the court's attention to in this judgment were paragraphs 91 and 92. My learned friend has taken you through them in some detail. The question is, as my lord has noted, whether there are exceptional circumstances in this case, which mean that the principles of Latin Martial can be departed from, and where the interests of justice lie in this case. If I can then take the court to the judgment of Judge Mandalia.
Yeah.
I have a note here in my speaking note to refer to him as a he. He is and that the judgment is at tab 7 of the core
57.
bundle. Page 57.
57 of the bundle.
Yes, page 57, that's right. The passages with which we are concerned begin at paragraph 22. This is where he considers the cross appeal. And that's at page 67 of the bundle.
Yep.
And we see at paragraph 23 on the following page that he refers to the decision in ENR at paragraph 92, which is not the correct paragraph. But I note that at paragraph 24, he says, I acknowledge that here the right of appeal is confined to errors of law. And that's important because, of course, paragraph 92 of ENR, the final paragraph says that we should emphasize that this analysis is based on the regime applicable to this case, under which the right of appeal to the IAT is not confined to issues of law. So it's clear from paragraph 24 that Judge Mandalia had in mind that he was dealing with a different kind of case where the right of appeal was confined to errors of law. And then at paragraph 25, he adopts the Latin Martial principles. And deals with the exceptional features in the case.
Yeah.
Just sticking for the time being to the question of what test he applied. It's true that at paragraph 28, he says that the principles are the starting point, which is perhaps an overly generous approach towards the respondent. But he also says at paragraph 30 that Farnwaith LJ spoke about the possibility of the Latin Martial principles being modified in exceptional circumstances. So taking all of that together, in my submission, it's certainly not clear that the judge was applying the wrong test. And he certainly considered the factors that he should have considered applying the test under paragraph 91, applying the correct test, which was to look at the exceptional features in the case and where the interests of justice lie. And so for the respondent to win this appeal, this court will have to consider whether, notwithstanding the quoting of paragraph 92, the judge was in fact applying the incorrect test. We say he wasn't, but even if you are against us on that, the question of whether the error was material then arises. So dealing with the question of whether the error was material, there are a number of exceptional circumstances which the respondent relies on, some of which are covered in the judgment, but there, as per the respondent's notice, are two further factors that we rely upon. But the first, which was noted by Judge Mandalia, is of course that the appellant was aware that there was evidence to substantiate the allegations made against him. And that is because in the unusual circumstances of this case, there had been an administrative judicial review procedure, a full hearing, which predated these proceedings. The second feature is that though the judicial review proceedings were on conventional public law grounds, in my submission, the conclusions of Upper Tribunal Judge Perkins, that the company that the claimant claimed to work for was a sham business and that there was no evidence of legitimate trading, means that there was no prospect of the appellant refuting the allegation of dishonesty, whatever the standard of review that was applied. So notwithstanding its conventional law principles, because of the evidence in the case, it wouldn't have made any difference.
But I haven't picked up from, and I might have got it wrong, I haven't picked up from UTJ Perkins any evidence that linked directly this appellant to the sham trading.
So the
And
company,
that's the point he makes in his witness statement, is that they might have been sham traders, but I didn't know about that and I wasn't involved in fraud. So there is that space, I think, between the two, isn't there?
well, I think
Potentially.
the company that he claims to work for is the sham business. So if they don't,
There's
he
nothing
submits,
there.
so he submits that he performed work for them and he's paid on a self-employed basis by them. And if those companies are sham businesses who had no legitimate trading, then it's impossible that he wasn't involved in the dishonesty.
So you say he
Well,
must
he
have.
says, doesn't he, in paragraph 13 of his judgment, there was evidence that the method of operation of the scam could be traced to this applicant.
Yes, so the confusion arises because there's two reports. There's the Operation Kajgong report, which is in the bundle, but it was commissioned in respect of a number of persons.
There's a list at the front, isn't there?
Yeah.
Yes, exactly. And this appellant doesn't feature in that in that prosecution. Those individuals are prosecuted. But there is also a report which deals specifically with this appellant, and that is behind the Operation Kajgong report.
And he's making the point, I think he's referring back there to what he says in 11, isn't he? I mean, the way in which this applicant, the way in which the payments to this applicant are set out is effectively the same as in relation to the named people.
Yeah.
And that's therefore evidence of his well, I think that supports that the method of operation could be traced to him,
Yes.
which is what he finds.
And a summary of the evidence that the respondent relied upon appears at page 127 of the supplementary bundle.
Yeah.
These are the pleadings of the respondent in that case. the detailed grounds of defense, pardon me, at paragraph 29. So they summarize the Operation Kudgegong report dated the 9th of August and the forensic accountancy report dated July 2014. Both of those you have in the supplementary bundle. So at the top of page 128, it sets out the income which the applicant declared, which was consultant pay from IWIN, and in each case, the payments are preceded by cash deposits to IWIN's account shortly beforehand. So that is what Upper Tribunal Judge Perkins, I think, is referring to. Yes, and so Operation Kudgegong, the report is at page 131, and the further report, which relates to this appellant, begins at page 247.
247.
Yes, 247, that's right.
So where in 247?
Oh, sorry, 247 is simply the beginning of the report, I should say.
Yeah.
It deals with IWIN and Radiant. If this appellant is his involvement appears at page 250. It explains that he applied for a Tier 1 visa and showed the income that he had claimed. Latupali, whose name appears in the Kudgegong report, he was named as a representative.
Oh, I see.
For that application.
This appellant received payments from Radiant Connect, which is one of the companies here so far.
Yes, and from IWIN Technologies.
Yeah, okay. Yes, I see.
The other exceptional circumstances that I rely on are that, of course, in my submission, the appellate misled First Tier Tribunal Judge Black about what he knew about the case against him. I know the court has my submissions on that point. The additional factors which are relied upon as set out in the respondent's notice are firstly, dishonesty is a matter of grave concern to the Secretary of State. And to illustrate the seriousness with which such conduct is viewed, the respondent has the power to deprive a person of their citizenship on the grounds of fraud, whether or not that deprivation renders the person stateless. And dishonesty by an applicant is a mandatory ground of refusal on an application for entry clearance or permission to enter pursuant to the immigration rules. I pause here to note a submission made for the first time this morning by my learned friend. Which is that the Secretary of State here is not tied with a bad decision. Where there is this dishonesty, the submission was that there were two things that she could do. She could refuse to implement that decision, or she could go back to the first-tier tribunal and say that it had been obtained by fraud and have the judgment set aside. The first thing to note is that this has taken me by surprise. It's not in the skeleton argument. I hadn't been aware of this submission. And if the court is considering that this, well, considers that the submission might be material to the outcome of this appeal, then I would ask for time to consider it in more detail and take instructions from my client about the feasibility of the course which the appellant has described.
There might be other routes by which you could achieve the same result. The issue for this court is whether this route was one which the upper tribunal judge was right to
To take.
agree with, as it were. And
Yes.
so the fact that there might have been other routes to the same result doesn't really matter.
I'm grateful for that indication. I would also say my preliminary observation is, of course, that in this case, she couldn't have gone back to the first-tier tribunal and complained that the judgment had been obtained as a result of fraud, because she had won at the first-tier tribunal. So if she had gone back to challenge the conclusions, the effect would have been to undercut the appellant's appeal to the upper-tier tribunal. I'm not sure that would have been fair. And in my submission, she adopted the appropriate course, which was to respond in those appeal proceedings and ventilate the issue there. It wasn't realistic. It wasn't an option for her to go back to the first-tier tribunal. I also note that one of the submissions that I'll come on to about there not being a safety valve for the respondent if evidence isn't admitted is that this course of action is only available in cases of fraud. So if there was a mistake of fact premised on some other matter, there wouldn't be another route. And of course, I wouldn't expect this court to condone or to encourage a party not to comply with judgments of the tribunal that they don't agree with. I'm not sure if there's much more I need to say about that submission made by my learned friend. But the respondent's submission is that if the evidence of dishonesty is excluded in this case, then without prejudice to submissions which would be advanced at the rehearing, if the first-tier tribunal accepts that the effect of Assan is that the respondent is obliged to treat the appellant as having accrued 10 years of lawful residence, which is what the appellant is arguing, then he would qualify for indefinite leave to remain and receive an unjustified windfall, which in the respondent's submission is clearly contrary to the interests of justice, given the fraudulent activity and the dishonesty in which the appellant took part. The other submission I wanted to make was in relation to the case, in fact, I'll leave that for the second ground. Those are the submissions that I wanted to make in relation to the first ground of appeal. Unless I can be of further assistance on that, I'll proceed to ground number 2. So in respect of ground 2, the appellant submits that there was no unfairness because the respondent herself was responsible for the error of fact. As I've taken you through the decision of Lord Justice Carnwaith in ENR, and paragraph 63 in particular, it's clear that the Court of Appeal is endorsing the approach of Lord Slynn. Not that they need to, of course, because that's the House of Lords, but that when it comes to a mistake of fact leading to unfairness, it is not necessary to find that anyone was at fault in order to arrive at this result. And so notwithstanding the upper tribunal judge's consideration of whether one or both parties were at fault in this case, it's not necessary to find that they were. It's objective unfairness which matters. And additionally, in our submission, there was fault on the part of the appellant. He wasn't required to adduce evidence which could be used against him, but he was required not to mislead the first-tier tribunal. A further point taken by the appellant is that the error did not relate to a fact because the judicial review proceedings were limited to a challenge on conventional public law grounds. And my first submission in relation to that is that a mistake of fact encompasses a mistake as to the availability of evidence, and that is set out explicitly in paragraph 66 of ENR. I don't think I have to take one word to it, but it is clear that an error as to the availability of evidence is sufficient, so the court doesn't have to decide that the appellant was dishonest. Here the mistake is whether there was evidence or whether it was an unsubstantiated assertion. And then finally, I'd like to take the court to the authority of Kabir, which my learned friend hasn't taken the court to in his submissions, but is referred to in the skeleton. If I can, Kabir appears at tab 2 of the authorities bundle.
Yeah.
And this was a case that had been relied on by my learned friend regarding the admissibility of evidence concerning the veracity of a letter. And in effect, in the proceedings below, the appellant had relied upon some bank statements, and the hearing was adjourned for the Secretary of State to try to verify those documents. She did, and she provided a verification report to the appellant solicitors, which, for reasons that hadn't been explained, hadn't actually been seen by the solicitors by the time the matter came to a hearing again. The appellant applied for another adjournment in order to consider that verification report, and the application was refused. And in the appeal proceedings, the appellant had obtained further evidence which contradicted the Secretary of State's evidence, so third evidence about whether the letter was genuine or not. And in that case, in Kabir, this court endorsed the upper tribunal's assessment that admitting that fresh evidence could lead to the hearing descending into a non-fathomable realm of allegation and rebuttal. And so the interests of finality clearly militated against admitting that letter. Now, I would say that, of course, the case of Kabir is not on all fours with this case, because we're not concerning allegation, rebuttal. This is an entirely different case where there was a volume of evidence which was entirely missing from the proceedings, and which the appellant knew about. And also there will be a rehearing in this case. And so there's no, the principle of finality doesn't weigh on this court's decision as it did in Kabir. But I would also note that at page 44 of the judgment, in agreeing with Lord Justice McComb's judgment, Lord Justice Underhill noted that the appellant's application to admit that fresh evidence would in any event be considered by the Home Secretary on any further application. So this is the safety valve at point, if I could put it that way. So Lord Justice Underhill says that sort of the fifth from the bottom, as Macomb LJ says at paragraph 35, and as Mr. Malik properly acknowledged, the fact that the documents belatedly produced by the appellant have not been considered by the tribunal means that they, and any other relevant fresh material, would have to be fairly assessed by the respondent if you were considering refusing any future application on the basis of deception. We say that is the case for appellants normally, but for a respondent, certainly on matters which don't concern fraud, but perhaps even in this case where fraud is, or dishonesty is alleged, there isn't that safety valve where the material will necessarily be considered unless it's admitted pursuant to ENR. Now, my lords, I pause there. Those were the submissions I had planned to make, but if I could just check my note to see whether there are any other matters raised by my learned friend which I wanted to respond to. Oh, there were two matters, in fact. My learned friend criticizes the respondent for not cross-examining the appellant at the hearing before the first-tier tribunal judge. In my submission, without documentary evidence to back up the allegations of dishonesty, it would not have been proper to cross-examine the appellant in any event.
Well, that may be right, but it would be said against you, you couldn't, should have produced the documents.
Yes, that's right. I can't get around that, but my learned friend seemed to be making an additional point.
Well, I understand the point as to whose fault as it was. It may have been within the Secretary of State's department.
Yeah.
It may not have been the person who was representing the Secretary of State before the tribunal. That's the point.
Yes.
Yeah. Okay.
My learned friend also made an additional, raised an additional matter this morning, that there was an error in paragraph 27 of the upper tribunal judge's decision in admitting the Rule 15A application late. So you recall that the Secretary of State in proceedings before the UT made an application to rely on that evidence late, and it was allowed. I would say that has not been argued before. It's not in my learned friend's grounds of
But
appeal.
it all gets subsumed into the exceptional circumstances point, doesn't it?
No, this is a separate point that you say that it's not open to him to challenge the admission of the application because nobody suggested until now there was anything wrong with it.
Yes, exactly.
So on the point about whether the application was properly before the UTJ, you say that's water that's flowed under the bridge.
Yes, exactly. He could have made that point in his grounds. The court would have decided permission or not. I would have advised my client it's far too late now to raise a separate error that he should not even have considered the application. But yes, the point about whether he should have, once the application was before him, whether he should have admitted the evidence, well, that's all to play for. There's nothing further I wish to raise at this stage. Can I be of any further assistance?
Can I just, one other point he made against you, just to have your submissions on it please, was that not you personally, but the Secretary of State's representative at the FTT should have invited an adjournment. That was an obvious procedural route to solve the problem.
Yeah. I don't have instructions on why that wasn't taken. So there's nothing really I can say, I don't think, factually about that.
Thank you very much, Ms.
Thank you.
Potter. Yes, Ms. Marriott.
When the court asked my learned friend if there was an explanation as to why the documents were not adduced below, she said there is no explanation. This is the most astonishing response from a government department, a public body, and I do not use those words lightly. How do we know whether it was merely an omission or a deliberate and informed decision made by the Secretary of State's former advocate to abandon the point? If it was an omission, why the Secretary of State is not saying so? It's not good enough with respect to say that there is no explanation. There's got to be one. I took the court in my opening to Rule 15(2)(a) of the Upper Tribunal Procedure Rules about submission of the evidence that was not adduced below. The rules are clear. There is an obligation on the Secretary of State or a party to provide an explanation as to why evidence was not adduced below.
What are you suggesting, Mr. Murray? We should adjourn, having made a direction that Secretary of State just to provide an explanation?
No, I'm not. All I'm saying is that
I understand the
that
point.
there is no explanation. No explanation was offered by her below, and when you look at the exceptional circumstances, so you consider that the context is that there is no explanation, no evidence that it was omission. How do we know, for example, that the advocate looked at the evidence, looked at the appellant's witness statement and decided not to challenge his credibility by exercising their judgment? So it is, in my respectful submission, quite extraordinary to say that, well, there is simply no explanation, but there is nevertheless an exceptional circumstance to justify allowing the appeal on fresh evidence. Now, my learned friend then made another submission. The submission that I say with respect is unfair one, which is that the appellant's witness statement to the first-year tribunal was misleading. How can the court decide whether that statement was misleading without hearing evidence from the appellant? Now, if a party says, if the Secretary of State's position was that the appellant's evidence at the first-year tribunal was misleading, she should have made an application to the upper tribunal to cross-examine the appellant and to put to the appellant the sort of points that my learned friend was seeking to make. It would be, in my respective submission, unfair for this court to make a finding of fact that the witness statement...
This court wouldn't do that.
No,
because we're either with you or against you, as it were. Obviously, if we're with you, then we dismiss the appeal. If we're against you, then subject to any submissions you make. So my own view would be that any factual issues would be issues for the first-tier tribunal. And the last thing this court would want to do is to trespass on matters which are not within our remit.
The problem is that my learned friend asks you to dismiss the appeal on that very basis.
Well,
On the basis that the appellant misled the first-year tribunal. That's her primary point. Now, how can, you have my submission that, well, this is too late for the Secretary of State to now come to this court to say that well, that evidence was misleading.
Yeah.
When she decided not to it's not a point about cross-examination at the first year tribunal, but why did she not make this point at the upper tribunal? Sought the upper tribunal's permission to cross-examine the appellant. It's too late to do that. In my respectful submission. Now I see that it's 1 o'clock now. I'm afraid I have 10 minutes. If you need 10 minutes, it's entirely up to you.
Should we go on? Yeah. Yeah, we'll go on if you've finished.
I'm very grateful. So that is what I submit in relation to this primary submission, that the court should dismiss the appeal on the basis that the witness statement was misleading. But if it was misleading, you have my point that there wasn't any cross-examination at the first year tribunal either. So it may well be the case that the advocate exercised the judgment and decided not to cross-examine the appellant. But on any view, my lord, milady, if you accept my lord and friend's invitation and proceed to determine whether the witness statement was in fact misleading, then everything that my lord and friend has said simply ignores the scheme of the procedure rules. Now, I have to take you, I'm afraid, to the witness statement to make the point good. The witness statement is in the supplementary bundle, page 252.
Yeah.
You will see, and I do submit that the Secretary of State cannot establish that the statement was misleading on any view. So if you look at paragraph 5.
Sorry, I didn't get the page
Yes,
reference.
page 252 of the supplementary bundle.
Paragraph 5.
He's so page 25. He's telling the judge that, well, I had applied for indefinite leave to remain. My application was refused. He's telling the judge at paragraph 7 that he denies the allegation. He's saying, well, the respondent must produce evidence to discharge that burden. I wasn't interviewed. No one ever had my explanation. Paragraph 8, I paid my taxes. Well, paragraph 9, this is the paragraph that Milan and Friend picked one sentence. There is no material against me that I had acted fraudulently. When anticipating that point, I took the court to Rule 24 of the first year tribunal procedure rules and MH. So the scheme is that if the Secretary of State has not filed evidence on receipt of the notice of appeal, the appellant will proceed on the basis that the Secretary of State is not relying on that evidence. So when he says there is no material evidence against me, he's saying, well, no material evidence has been adduced in these proceedings against me.
This statement was actually signed a week before the hearing, before the first tier tribunal. So the date by which the Secretary of State should have filed any evidence had long passed.
Wait.
It was actually a point you made in opening, I think.
Yes, and that's why I took the court to the rules and MH. There's no answer by the letter trend to that point. She's not saying MH was wrongly decided, but that's how the parties proceed. Now I do say that this wasn't an inquiry. That the first year judge wasn't conducting an inquiry where all parties were required to cooperate to come to a correct decision. The burden of proof was on the Secretary of State, and I do ask, my lords and my lady, if my lord and my lady finds any force in the point that my learned friend makes, and take the view that it is appropriate to decide whether this is a misleading statement or not, to read the statement as a whole. I mean, see the next few paragraphs. He deals with the bank statements, the issues, and then paragraph 14. It is important that I am aware of the case against me and all material documents are properly disclosed. This is minding the Secretary of State that, well, you haven't really disclosed anything against me. And paragraph 10 too, where he refers to the refusal letter, refers to the investigation into the companies. And I do also respectfully and firmly contest the submission that, well, the evidence against the appellant is overwhelming. It's not. It's not. It's not. So there is no evidence that links the appellant directly to the two companies. I'll give Malord and Milady's an example. So fraudsters, in order to run a scam, may well need services of genuine suppliers. I mean, what about a cleaner who is cleaning a fraudster's office, and the fraudster is paying that cleaner for cleaning? I mean, what about the fraudster taking advice, for instance, from a lawyer or an accountant or an IT specialist? So this suggestion that because one of the many suppliers of that fraudster was the appellant, he was somehow dishonest, is with respect untenable. And I do, and all this points to the submission that I made earlier, that it is given that you don't know why the point wasn't taken, that it was a matter for the advocate's judgment who appeared at the trial, and in my submission, the judgment was exercised correctly. He decided not to suggest that the appellant was dishonest.
Yeah.
On this evidence, he wasn't. So this is not a case of overwhelming evidence. Now, my learned friend then says that, that although the evidence itself may well be contentious, the availability of evidence is not contentious. And that's why she says that that's good enough. And she refers, in relation to that point, to a sentence at paragraph 10 of the judge's decision. The judge said, in terms of the appellant's undesirability, there is an unsubstantiated assertion. I mean, what the judge obviously meant was that the assertion was not substantiated before at those proceedings.
Yeah.
But more fundamentally, I do ask my lords and my lady to consider how attractive this argument is. But by reference to this example, in every fresh evidence case, the existence of fresh evidence, the availability will not be contentious. There will always be fresh evidence that the party would seek to put before the court. And to admit that evidence simply on the basis that, the evidence exists and it's not contentious that the evidence is available, would make Laird and Marshall entirely redundant.
Yeah.
It is, with respect, a bit too rich for my learned friend to say that I have made a new point in my submissions that the Secretary of State can take other actions. This, in fact, is the point that my learned friend made for the first time in this court, that the Secretary of State is bound by the first tier's decision. Her hands are tied, she can't do anything. This was not an argument that the Secretary of State made before the upper tribunal. This isn't an argument that the upper tribunal decided. The point was made for the first time in this court in the respondent's notice. And the point the point for the reasons I've given is wrong. But another point that my learned friend makes in my submission actually demonstrates that this point is wrong. So you'll recall that my learned friend referred you to the provisions as to the deprivation of British citizenship. If there is British citizenship obtained by fraud, the Secretary of State can revoke it. If indefinite leave to remain is obtained by fraud, the Secretary of State may revoke it. That really is an answer to this point that the Secretary of State makes, or at least one answer, that her hands are tied. If the applicant gets indefinite leave to remain, she can surely revoke it. She can surely revoke it on the basis that it was obtained by deception, if she is satisfied that it was indeed obtained by deception. So it's certainly not the case that that the Secretary of State is simply bound by the decision. Her hands are tied and she can't do anything about it. When I was making my submissions in opening, lady, you asked me a question that, what if something has gone wrong in a case where there was some exonerating evidence, and the appellant comes to this court saying that, that evidence was missed, and you have my submissions that you will consider all sort of factors that I had that evidence in my position, decided not to cross-examine him. But there is, with respect to a further point, will you not ask me, milady, if I'm in that position, that, why are you in this court seeking to disturb the case law and the statutory scheme, why don't you just go to the upper tribunal, say that there is a procedural irregularity in the decision-making process, there was evidence that wasn't considered, that was there, and ask them to review the matter or to set aside the decision. This is what the upper tribunal said in Avasi, that if there's evidence of fraud, then go back to the tribunal, ask them to open the proceedings. The point about admitting of new evidence that I made in my opening is not, I do emphasize, is not a freestanding point. And I apologize if I gave the impression that it was a sort of freestanding ground of challenge. But I do say that when it comes to considering whether there are exceptional circumstances, that really is the reason why I made my point. The court will have to consider not only all the circumstances that I highlighted, but also the fact that the evidence on any view was way out of time. And that surely is a relevant matter in deciding whether there are exceptional circumstances. I mean, and finally, Lord, ladies, I refer to Kabir in my skeleton. I was in that case and felt obliged to bring it to the court's attention. But you'll see that was a case. It's quite different. All you have to do is to see paragraph 38 to see why it is so different. That was a case where the Secretary of State actually produced a document verification report at the tribunal. The appellant did not answer to that, provided no evidence. And once the appeal was dismissed, he then came up with some evidence saying that, well, I have this new evidence, admit it, because the Secretary of State, because the judge made the wrong decision. The court dismissed the appeal for the right reasons, saying that, well, it's a bit too late. You had all that evidence, and what was true for the Secretary of State, what was true for the appellant in Kabir, in my submission, is equally true for the Secretary of State. It's far too late for her to rely on this evidence. Very grateful.
My lord, I just raise at this juncture, somewhat unusually, to say that I want to clarify something. I didn't mean to mislead the court when I said that I didn't have any explanation for why the documents hadn't been given. I just want to clarify. What I meant was I don't have a good reason for why they weren't provided to the first-tier tribunal, but I have instructions that it was an omission and not a deliberate.
Well, I'm speaking for myself. I assumed it was a blunder rather than a conspiracy, if I can put it that way.
Yes, and I have instructions that it was a blunder, and I can show them to my learned friend.
I apologize. Can I just very quickly respond to that? Well, if a party in a fresh evidence case says that the evidence was not adduced by omission, or there was a fault of representative, I mean, it's a matter of evidence. That party has to provide evidence to make that point, not at this court, but at the court where she was seeking admission of the fresh evidence. So if it was an omission, where is the evidence, and why that evidence was not adduced at the upper tribunal? Very grateful. So unless I can assist any further, these are my submissions.
I don't think we're going to. No, thank you very much. Well, thank you to both parties for your helpful submissions. We will reserve our judgment. We will let you have a copy in drafts as soon as we can. That will be for correction of any typographical errors, not for inviting the court to revisit any decision that's made. And please, can you pay attention to the terms of the rubric of the embargo at the top of the judgment as to whom any copies are provided and for what reasons. Thank you very much again.
Court rise if able.
Wait and see.